That is a pretty common question that I get asked, do I need an attorney? And the answer is no. As the state of West Virginia, I represent the victim's interest in the case as the prosecutor, which means that although I'm not your attorney, I represent your interest as the victim in the case. So the short answer is no, you do not need an attorney. That's a complicated answer, and the answer to that is maybe. But although you never have to communicate with them directly, the only time that you would have to see them is during trial or during a hearing. And during those times, you would be sitting on the witness stand and only subject to cross-examination. And that means that if you did have to see them, they would be sitting at an opposite table next to their counsel, and their counsel would be talking to you. And that is absolutely not a situation where you're face-to-face with them alone in any setting at all. No, unfortunately, you cannot report a crime anonymously. And if prosecution is commenced against the person or the perpetrator that did this to you, they will eventually find out. And that is because the Confrontation Clause of the Constitution does permit them to confront their accusers at trial. And although they might not find out immediately, they will find out at some point. So the short answer is, even if you're a witness in a case and not the victim, you will not remain anonymous. A victim impact statement is an opportunity for the victim to tell the court and tell the perpetrator and tell anyone that was involved in the case, whether that be positive or negatively, how they feel, how they were affected. And what's really important to know is that although the defendant has a lot of rights during trial and during the prosecution of a case, so does the victim. And that's through the Victims' Rights Act of 1984, and that was actually codified. So what that means is that's actually a law, and the victims have rights. And what that means is you're able to speak your piece. And that's usually before sentencing, which means that the person has been convicted either via plea or a verdict at trial, and you're allowed to tell a judge exactly how this affected you before the judge passes a sentence. That question, it depends on a few things. Obviously, for prosecution, the best time to report a crime is as close to the crime as possible. However, that doesn't mean that you have to report a crime when it happens, especially crimes of sexual violence and domestic violence. Usually, it can be hard to report that right as it happens, especially if it's a dangerous situation. But for evidence purposes, it's always important to preserve evidence, whether that be DNA evidence, to preserve the scene. Those are important things that need to be contemporaneously preserved with the crime. However, just because something isn't reported right when it happens doesn't mean that you shouldn't report. Felonies or sexual assaults, things that are penalized by code over a year, those things don't have a statute of limitations, which means there is not a time period with which prosecution can commence. However, I will go back to the point that it is important for the prosecution, for police, investigators to preserve evidence as close to the crime as they can. Misdemeanors do have a shorter statute of limitations. They can only commence prosecution a year after the warrants have been served. And those are the domestic assaults, the domestic batteries, and things of that nature. So those are also, that's also an important factor to take into consideration. But just because you're not reporting a crime right after it happens does not mean that you should not report it. Even though something can't be prosecuted, it's extremely important to report to police so that they can do a report and that there can be a paper trail, no matter what. So there are certain steps that you can take to prevent your abuser from harassing you after you report. And usually, what should happen after you report a crime if criminal charges are commenced. There should be something called a no contact provision of the bond, and that is a per se protective order. And what that means is there's a protective order in the conditions of the bond that can be prosecuted as a new offense. So if the defendant or the perpetrator contacts you via text message, phone, even a third-party contact, that can be a new criminal charge. So that is a way that we can keep that person accountable for staying away from you. A lot of people don't know that. Also, if the abuse or harassment after the fact rises to the level of extreme harassment or even violence, that could be a new felony charge in itself, because the state takes it very seriously when a witness or a victim of crime is threatened or intimidated or retaliated against. So there are measures that can be taken to protect you after your report, but again, the communication lines have to be open. I tell my victims all the time that you can call me anytime, day or night. My office phone rings to my cell phone, and I even give out my cell phone number. So as long as I know, I can help you. If you didn't actually say the word no, that does not mean that you consented. You have to take the circumstances, all of the circumstances, into consideration, and that's what we do as prosecutors. So just because you didn't say no does not mean that you consented to whatever happened to you. There are other ways of saying no than verbally saying the word no. If you were drinking, that does not mean, first and foremost, if you were drinking, that does not mean that you deserved whatever happened to you. However, drinking does affect your memory, and the unfortunate part of that is that if charges do proceed to trial, memory is one thing that defense attorneys, good defense attorneys, decent defense attorneys do attack. So the drinking factor is going to come into play when you are on the stand if it proceeds to that point. However, I will mention only about 1% of our cases ever proceed to trial, so the chances of that happening are very, very low. But it is a factor to consider, that we do consider, but we can absolutely talk about that. There's no answer that I can give someone that says your drinking did or did not affect the case, but we can absolutely consider those circumstances. I just have to mention that drinking does affect the memory aspect of things, but just because you were drinking alcohol does not mean you consented to whatever happened, or that you allowed someone to abuse you in any way. The short answer to will the offender be able to get out on bond is maybe. Every offender pre-trial is allowed to post a bond, and they are entitled to a reasonable bond. So what that means is the reasonable bond depends on what kind of case it is. It depends on the circumstances that surround the charge. It depends on what their criminal history is. There's a whole slew of circumstances that the judge has to consider that we argue to say that the bond should be extremely high, and that would be reasonable, or that the bond should be low, or that this person should be on home confinement. So the short answer to that is maybe. Pre-trial, every defendant is entitled to a reasonable bond. So maybe. Absolutely not. If you're underage and you accept gifts from a perpetrator or someone who's abused you, that's actually a circumstance that I would strongly encourage you to report to law enforcement, because there are several underlying factors that maybe the victim of that crime isn't considering. A lot of times that's a way for an offender to manipulate the victim. That's something that we commonly in law enforcement refer to as grooming. So that's a very common technique, and I would encourage whoever would be on the receiving end of those gifts, especially if you've been victimized by this person, to approach law enforcement without any fear of being charged for anything. If you report a crime and then change your mind, the first thing I'll say about that is that it's absolutely very common for my victims of domestic violence and sexual offenses to change their mind several different times. It's actually more common than not that somebody reports a crime and then changes their mind about what they've done 100 different times. The only thing that's important is that you always tell the truth and that you communicate with me as the prosecutor in the case, or any prosecutor of the case, about how you're feeling during the case. It's not uncommon for a victim that's endured that kind of trauma to go back and forth several times about what they're feeling, how they're feeling about going forward. The only thing that I would say that I would encourage the victim of the crime to do is keep those lines of communication open so that we can help you reach out to certain resources that can navigate this with you, that can hopefully connect you to some people that have been through the same thing and keep you clear as you're experiencing these types of emotions. The answer to that question is always going to be yes. Should you report any type of crime that's happened to you? Yes, always. And especially the crimes that can be classified as domestic crimes or sexual violence. No one ever has the right to abuse you in any way, make you feel less than or less than a human being. And even if, I'll reemphasize, even if the prosecutor or the police, they can't charge a crime, that does not mean that you should not report and that the police officers can't make an official report and have a paper trail so that if this ever happens again, to you or to anyone else, that we have it on paper, we have a record, and we know that this certain individual is capable of these types of acts. So yes, always report, no matter what the outcome could be. That's always something that is encouraged. There are several different difficult parts of my job, and one of them is that I can't put my victims in a bubble and protect them every step of the way. However, there are things that we can do to make sure that you're protected before, during, and after criminal prosecutions are carried through. And one of those things is the VINE system. The VINE system is it's an app that you can download on your phone. I have it on mine. And what you can do is once that person, your offender, is in jail, if they are in jail, you can enter their name in and they will send you a notification, whether that be a call or a text message, as soon as that person posts a bond. And if you don't have a phone, usually what I do is I put it in my phone and I'll find a way to alert the victim the minute that they're released, whether that be at 2 in the morning or 8 in the morning, it doesn't matter. Once that person is released, we talk about a safety plan, and that means what are you going to do if that person does approach your home? Do you have a bag pack? Do you have somebody that is able to take you in at very short notice? Do you know how to protect yourself in case of emergency? And those things are all really, really important to talk about with the prosecutor, talk about with the victim's advocate, well before any of those things come up. And I'll mention once again that if the offender ever comes after a victim in retaliation to criminal prosecution, then there are absolutely severe penalties that can be imposed and prosecutions that can be commenced against that person. The most important thing to do is to keep that line of communication open with law enforcement and with the prosecutor so that we know exactly what's going on. If you let us know, we can help you.